Hello. Today we're going to give you an introduction to the office memorandum, which is a memorandum that you usually are writing to a partner or an associate that you're working for when they ask you a question, and it's not just a quick elevator question where they want an answer in 5 minutes, but they ask you a question and give you a bunch of facts and they want an answer about the law. You write them a full memo. And what will happen is a lot of times will take it down and use your memo to help answer the question when they write a client letter or go see the client or have to put something into court. So we are going to get started. Please note that the sample memo that I'm using has some different words than were used in your reading, but your reading did include these words, and I will note them as we go on. So here is on your right is what a memo would look like when you put it all together. Um, yeah, so a memo explains the purpose of the memo is to explain the relevant law to a particular question. It means that you are writing in light of your client's facts. It is not a research paper. You are not giving all of the law on the history of a particular law unless that's what you've been asked to do. Generally, an attorney uses this document to help them make a decision. So they may disagree with your decision at the end, but the information inside is being used to help them reach a decision. They want to know what course of action they should take and whether or not something would likely, usually whether or not something would likely be successful. Sometimes they use it to help explain something to a client. Either way, it is not something a client usually sees. It is never something that opposing counsel sees. It is considered work product. But when you write it, you want to be objective. So you want to give the good and the bad because you are being objective, because you don't want your attorney to be caught by surprise if there are some bad things that don't work in your client's favor. You want to be accurate and you want to be honest. It is basically a broad overview. It explains the relevant law to a particular question. It is often analyzed how a court might apply that law to your case. It is called predictive writing. That's what kind it is. You are predicting the result based on a particular problem or set of facts. You are not trying to persuade the reader the way you would persuade a judge. This is not the time for you to advocate. So you again need to objectively look at the strengths and the weaknesses of your client's case against the law. It is a neutral assessment. It considers both the strengths and the weaknesses of your case against the law and predicts the most likely outcome. Again, I will say it until my face turns blue. It is an objective analysis. The substance of an objective office memorandum is to explain the law and apply the law to the facts of your client's case. The two components, an explanation of the law and then an application of the law to your client's case, are the core components of a legal argument. These are the main focus and the largest part of your memo. When you conclude, it is important that you acknowledge any bad news and that you consider if there's any alternate strategies. Why do we want to consider the bad news and alternate strategies? Well, usually office memos, a lot of times, not usually, but a lot of times office memos take place right after a client walks in and they want to know whether or not they have a case. And the lawyer will tell you the facts and say, do you think that this person will win? And you research the law and you come back and say to your boss, no, I don't think they will win, or yes, I do think they will win. Well, if it's a personal injury case and you're representing the plaintiff and you don't think they will win, well, then all of the work that was done for that party means that you're not going to get paid, because usually plaintiff lawyers are paid based on contingency fees. And if you're not going to win, you're not going to get any fees, because contingency fees means you get a certain percentage of the verdict. So you want to make sure you give the lawyer all of the news so they can decide whether or not to take a case. Every law office has its own style memo. And every law office calls parts of that memo different things. But all memos typically have 5 parts: an introductory statement that briefly lays out the question that you are asked or the question the memo addresses, a concise answer to those questions, a fact section, a discussion that analyzes the question, and a conclusion. That was the form. So here's the default memo format. I'm going to point out what you were told in your reading and show you some other options. So a heading is in all memos, or else it's not a heading. Then your reading called it assignment. Other places call it an issue statement. The sample that is going to be on the screen in a minute calls it a question presented, but it's all basically the same thing. Then after that, and that would be the intro that I just talked about. Then after that, you have a short answer, which is what your reading called it, or a brief answer, which is more formal. And it's what the picture on your screen will show. Then you have facts, or a statement of facts, which are the facts of your case. Then you have your discussion or analysis, and then you have your conclusion. So the memo heading is basically the to, from, date, and re. So you have the to, the attorney's name for this memo was Sam Stevens, from legal intern. Um, the date is the date that you wrote it. The date must be accurate, because if your lawyer is paying attention, the date certifies that this was the last time that the law contained in that memo was checked on whether or not it is good law. So you must verify that the law that you're relying on is good law. And so if the law changed November 15th of 2025 and your hearing was in January and they're relying on the law in this memo in January 2026, then there may be malpractice, because the law changed November 15th of 2025. So you need to make sure that the date of your memo is accurate, that you checked the law was good as of that date. And then the re is what the case is about. You need to remember that most law firms hold memos in their records, so that somebody will probably use this memo later as well. They won't just cut and paste it, but they may use it as a start for their research. So they need to be able to get an idea of what the case is about based on the re line or regarding line, so that they know whether or not there will be something in that memo that may help them. After the heading, you go to the assignment. In the picture, it's called the question presented. Notice that the title is underlined all caps in bold, and the assignment itself identifies 4 things: the law, the jurisdiction, the key facts, and the question asked. So this is where you basically say back to the lawyer, this is what you asked me to do. And you don't say, this is what you asked me to do, but you say it a little bit more specifically. So under Florida law, can X, where, Y? But that's the assignment part. Next comes your short answer. Again, here it was called the brief answer. And this is the short answer to the question presented or the short answer to the assignment. This way, if the lawyer is really busy, they could just read that one paragraph and boom, they have their answer. Now they know whether or not they want to read more or not. If your answer is no, um, we will not be successful, then they may not want to read anymore because that was originally what they thought too. And they said, oh, I was right. Okay. The lawyer has hundreds of cases under their belt. They may not want to spend any more time reading it. But so this is where you give the answer to the assignment. It is a synopsis of your analysis. It's not just a no or yes. It basically takes everything you write after it and put it into one paragraph. After the short answer comes your facts. Here you tell your story. Tell the story of what happened. Telling the story includes three different kinds of facts: background facts, emotional facts, and legally significant facts. Background facts is what the reader needs to know to understand what happened before and why that was bad. So, I mean, you don't need to go back to the birth of the parties, but, what was the relationship of the parties or where did this happen? Why does that matter? The emotional facts are the things that might make a difference to a jury or might make a difference to the listener. So if it was a slip and fall, it wasn't just a slip and fall, but it was a slip and fall of an 86-year-old woman using a cane, which might be emotionally different for somebody on a jury than it was of a 40-year-old yoga instructor, right? So think about what may be emotionally relevant to somebody listening to the story. And then there are legally significant facts. These are the facts that the courts take into consideration when they are using the rules to determine whether or not a party will be successful. But you need all of them to be able to tell a story because you want this to be a narrative. This is not bullet points. Your facts section should be a narrative. You should actually be telling a story. Following that, you get into your discussion or your analysis, and this is the meat and potatoes of your memo. This will be the longest part of your memo. As the name reflects, this is where you're going to perform the legal analysis that supports your prediction. Your discussion or analysis section includes a point heading, introductory law, and your legal analysis. Now, how do I do my legal analysis? Well, you do that by what I'm going to call CREAC. Most of you have heard of IRAC. If you had any interest in law school or you've watched any law school movies or anything, they all mean the same thing. These are all different mnemonics that stand for the same thing. Legal analysis and legal writing is all done in basically the same order. You start with a conclusion, or you start by stating the issue for IRAC. You then give the legal reader the rule. Then you explain the law, where that rule came from. Then you take that explanation and you apply that to your facts. And from there, you restate, not in the same words, but you restate your conclusion based on the facts and based on the application of the facts you just gave. I use CREAC. You could use treat, which is thesis, rule, explanation, application, thesis. You could use IRAC, which is issue, rule, application, conclusion. They're all the same. Trust me. And after you have done your discussion or analysis, you end with a conclusion. Again, note that it's part of the same thing, so it has a heading, which is all caps, bold, and underline. The conclusion is the last section of your memorandum. It does three things. It answers the question asked in the assignment or question presented. It predicts what the court is most likely to do. And finally, it also includes recommended strategies or next steps for the attorney to consider. So if there's something that you found in your analysis, if you had said, no, this will not be successful, but there's something that you found in your analysis that would turn this to and if that had occurred, it would be successful. Perhaps if you took a deposition and found out that that had occurred, it would change your answer. Perhaps taking discovery and finding something out would change your answer. So it would be doing something like that, but to change your answer. Or if you're on the fence, it's maybe finding something else out that would help solidify your answer. But what would you recommend the attorney do next? Again, here is the default memo format, heading, assignment, short answer, facts, discussion, and conclusion. I'm sure right about now I have made your head spin. That's why this is a recording, so you can watch it again if you want. I thank you for your time. I will see you all soon. Don't forget, if you have questions, you can, of course, always contact me. We will be discussing CREAC in the discussion section again, so do not panic and have a good one.